Let's assume you're introducing the statement for the truth of the matter asserted. Here you would check yes. Now you have three options to classify the statement. First, is it by a party and offered by the opposing party? This makes it an admission by party opponent. Second, the statement is by a party, but it's not offered by the opposing party. This does not qualify as an admission by party opponent, since your statements are not offered against the opposing party. Third, the statement is not by a party. In this situation, you would simply go to Rule 803 to see if it meets any of the exceptions under that rule. So let's first screen the statement to see if it qualifies as an admission by party opponent and is in fact offered by the opposing party. The rules give us 6 different types of statements that can qualify as non-hearsay. First, a statement by an opposing party. We refer to this as an admission by party opponent, but it does not have to be an admission, it only has to be a statement. Next, you'll need to show that the statement was made by the party in an individual or representative capacity. Note that a party cannot introduce their own statement under 801. Next, a statement by the opposing party's agent or employee if it is made in the scope of that relationship and while the relationship existed. The next statement is one the opposing party has adopted. You will have the burden of convincing the court that the opposing party heard and comprehended the statement of another. Once the court makes that determination, you will have to show one of 3 things: that the party expressly or implicitly adopted the statement, or 2, that the party acquiesces in the statement of another, or 3, the party's statement results in adoption of the statement, and a reasonable person would have denied the statement. The next admission by party opponent is the statement of a person that is authorized by the opposing party. The party must establish evidence that the juror could conclude that the party opponent authorized the declarant to make a statement on the subject. Note that the statement itself may be considered in establishing the predicate, but does not by itself establish the declarant's authority. The 5th statement by a party opponent is a statement by a co-conspirator. First, the declarant and the opposing party must be members of the same conspiracy. The statement by the declarant must be made during the course of the conspiracy, and the statement is made with the intent to further the conspiracy, as opposed to, for instance, just idle criminal chatter. Finally, for the statement to be admissible, the court makes a finding by a preponderance of the evidence that based upon the contents of the statement and some independent evidence, the conspiracy existed. The 6th statement by a party opponent is a statement by a defendant who filed a cross-claim, and such statement is offered by the co-defendant against the party who the cross-claim was filed. If a statement is not an admission by party opponent or not a statement by a party, the next category of statements are not hearsay by definition. These include certain statements made by the declarant who is subject to cross-examination. The first type of statement is a prior inconsistent statement. First, you need to make the determination that the prior inconsistent statement was made in either a sworn statement in a deposition, or a sworn statement in a grand jury, or a sworn statement in a trial, or a sworn statement in a prior hearing or other proceeding. After making this determination, it must be shown that the statement is inconsistent. If the witness has testified at trial and is subject to cross-examination at trial, the prior inconsistent statement is admissible, and it comes in as substantive evidence. If the witness did not testify at trial or is not subject to cross-examination, the statement is not admissible, and you would next proceed to Rule 803 to see if it meets any of the exceptions. Let's back up to prior consistent statements. Generally, prior consistent statements are inadmissible as hearsay, except for 3 exceptions. The first exception is a prior consistent statement that is used to rebut a charge of recent fabrication, or the prior statement is used to rebut a charge of improper motive, or the statement is used to rehabilitate the declarant's credibility as the witness has been attacked on other grounds. Now, the next statement that is admissible is if the declarant is subject to cross-examination, is a statement of identifying a person. An example of this would be a witness making an identification after viewing a lineup, and that statement is then testified to by a police officer. If the evidence does not meet any of these definitions, the evidence would next be screened under Rule 803. Please proceed to the video on Rule 803.